Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about stolen cars. Cases that should have gone to the Supreme Court of Canada, but didn't. In a Vancouver car lot, a car lot attendant left a car running with the keys in the ignition for about 40 minutes. The car was stolen. A police chase ensued, in which an officer was ultimately struck by the stolen car driver and suffered serious injuries. Ultimately, he sued the car lot, arguing that the employee was negligent in leaving the car there and was responsible as a result for his injuries. He succeeded at trial, but the judgment was overturned by the BC Court of Appeal, who determined that a car lot would not be responsible for the injuries a police officer suffered in an ensuing car chase after the vehicle is stolen over an hour later. And this case raises very important issues about the question of causation and foreseeability. In any civil claim, the question of whether or not somebody's injuries are caused by another individual and whether or not the injuries are foreseeable is something that has to be determined by the court. There's been very little guidance from the Supreme Court of Canada on this issue in recent years. And while it's reasonable to assume that if you leave in the Lower Mainland a car running in a lot for 40 minutes that it's going to be stolen, and it's reasonable to assume that if it's going to be stolen, the police are going to be involved, the Court of Appeal determined that it wasn't reasonable to assume that the police actions would result in an officer becoming injured 40 minutes to an hour after the car was initially stolen. And this is an important question, because what is it about foreseeability that has this temporal limitation that the court ultimately imposed in this case? When you can easily see how a stolen car could lead to a police chase, we've seen this happen in numerous police videos and those high-speed chase television specials that come out, and in movies. It's not unforeseeable, it's not outside the realm of imagination, and it's not even remote. It's reasonably possible. So how could it not be that the employee and the car lot were not responsible for the actions that ensued, because all of it is an extension of the same initial act of negligence? The Supreme Court of Canada could have clarified why this temporal limitation of about an hour was placed on the foreseeability doctrine in this case, and why it functioned to prevent the officer from being able to seek compensation for his injuries from the car lot, who were the ultimate cause of his injuries when you worked back through the chain of events. This would have been an important opportunity for the Supreme Court of Canada to provide more clarification on civil issues that are often not addressed in this country, and unfortunately it's going to take another case involving hopefully an interesting set of facts to bring these issues to light in front of the Supreme Court of Canada. Cases that should have gone to the Supreme Court of Canada, but didn't. Thanks for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Please like, subscribe, and share with your friends.